A federal judge just invoked a procedural mechanism so rare that legal historians are comparing it to judicial actions from the Watergate era, and Trump's legal team was given less than 24 hours notice before the order took effect. Judge Michael Fitzgerald of the Central District of California issued what is known as a sua sponte recusal and reassignment order, which means he removed himself from Trump's case and simultaneously transferred it to a randomly selected judge known for running an exceptionally strict courtroom with zero tolerance for delay tactics. This type of judicial action, where a judge voluntarily steps aside while explicitly stating concerns about a party's litigation conduct and ensuring the case goes to a judge with a specific reputation, has not been documented in federal court records since 1974, when judges handling Nixon-related cases took similar steps to ensure proceedings would not be manipulated through judge shopping. Hit the subscribe button right now because you won't want to miss any of the videos I release. So, what exactly prompted Judge Fitzgerald to take this extraordinary step? And why did he specifically ensure the case would be transferred to Judge Sarah Chen, whose reputation for aggressive case management and quick trial schedules is legendary among federal practitioners in California? The case involves a civil lawsuit filed by former Trump campaign staffers, alleging they were not paid wages owed to them and that they were retaliated against when they raised concerns about financial irregularities in campaign operations. The lawsuit was filed in August 2024 and was assigned to Judge Fitzgerald through the court's random assignment system. For the first 5 months, the case proceeded relatively normally with standard scheduling orders, initial disclosures, and preliminary motion practice. But according to court records and reporting from Legal Affairs, journalists who cover the Central District, Trump's legal team began employing delay tactics in January 2025 that Judge Fitzgerald apparently concluded were designed to prevent the case from ever reaching trial. The tactics included filing a motion to dismiss based on claims that the court lacked personal jurisdiction over Trump, even though Trump had already appeared in the case and participated in discovery without raising jurisdiction objections for 5 months. Federal procedural rules generally require jurisdiction challenges to be raised at the earliest possible opportunity, and courts typically find that defendants who participate in cases for months without objecting to jurisdiction have waived those objections. Judge Fitzgerald denied the motion and noted in his order that the jurisdictional argument appeared to be raised for purposes of delay rather than based on any good faith belief that jurisdiction was lacking. Trump's legal team then filed a motion for summary judgment, arguing that even if all the plaintiff's allegations were true, they would not be entitled to relief as a matter of law. Summary judgment motions are common in civil litigation. But Judge Fitzgerald's order denying that motion included unusual language, suggesting he believed the motion was filed despite defense counsel knowing it lacked merit. The order stated that the arguments presented were contradicted by clearly established law and that competent counsel should have recognized the motion was frivolous before filing it. Following those 2 unsuccessful motions, Trump's attorneys filed a motion to transfer the case to a different district, arguing that Florida would be a more convenient forum because Trump resides there and because many witnesses are located there. Venue transfer motions are also common, but Judge Fitzgerald's order denying transfer noted that Trump's team had not explained why convenience concerns were only being raised 5 months into the case after Trump had already participated extensively in California proceedings. Smash that like button if this is making sense so far. The breaking point came on January 26th when Trump's legal team filed what they characterized as a routine motion for extension of discovery deadlines requesting an additional 6 months to complete discovery. The motion argued that the complexity of the case and the number of potential witnesses required additional time. However, Judge Fitzgerald reviewed the case docket and determined that Trump's team had conducted minimal discovery during the 6 months already allotted, had failed to respond to multiple discovery requests from plaintiffs within required timeframes, and had not scheduled or completed depositions of key witnesses despite having ample opportunity to do so. His order denying the extension request included a detailed recitation of Trump's discovery failures and concluded with language that is extraordinarily rare in federal court orders. Judge Fitzgerald wrote that the motion for extension appeared to be the latest in a series of filings designed not to advance legitimate litigation objectives, but to delay proceedings indefinitely in hope that plaintiffs would abandon their claims due to the time and expense of continued litigation. He noted that such tactics, if that is indeed what the court was observing, would constitute abuse of the judicial process and could warrant sanctions, including referral to disciplinary authorities. Then came the truly unprecedented part. Rather than simply denying the extension and proceeding with the case on his own docket, Judge Fitzgerald issued a supplemental order the following day announcing that he was recusing himself from the case pursuant to federal statute that permits judges to recuse when their impartiality might reasonably be questioned. The order explained that Judge Fitzgerald had formed strong opinions about the conduct of defense counsel based on the pattern of filings he had observed, and that those opinions might affect his ability to remain impartial in future rulings. To ensure both parties received fair treatment going forward, he had determined recusal was appropriate. Here is where it really gets serious. The order did not stop with simple recusal. Judge Fitzgerald invoked a rarely used provision of local court rules that permits a recusing judge to request that the case be assigned to a specific other judge. When the recusing judge believes such assignment is necessary to ensure fair and efficient proceedings. Normally, when a judge recuses from a case, the case is reassigned through random selection, just like initial case assignments. But this local rule, which exists in several federal districts but is almost never actually used, permits the recusing judge to recommend a specific successor judge if circumstances warrant. Judge Fitzgerald exercised that authority and requested that the case be assigned to Judge Sarah Chen, and the Chief Judge of the Central District approved that request within hours. Judge Chen has been on the federal bench since 2015 and has developed a reputation as one of the most efficient and demanding judges in the district. According to attorneys who practice before her regularly and who spoke with the American Lawyer magazine and other legal publications, Judge Chen typically moves cases to trial within 12 to 18 months of filing, maintains strict control over discovery schedules with little tolerance for extensions absent genuine emergencies, and imposes significant sanctions on attorneys who fail to comply with court orders or who engage in tactics she views as dilatory. She has a particular reputation for quickly identifying and shutting down strategies designed to delay proceedings, and she has referred multiple attorneys to disciplinary authorities over the years for conduct she found violated professional responsibility rules. The assignment of Trump's case to Judge Chen was clearly not random, and Judge Fitzgerald's order made that clear by stating that he believed the case required a judge with particular experience managing complex litigation, where parties may attempt to manipulate procedures to avoid accountability. Legal experts immediately recognized this judicial maneuver as extraordinary and is sending a powerful message about how Judge Fitzgerald viewed Trump's litigation conduct. Stanford law professor Nora Freeman Angstrom, who teaches civil procedure and has studied judicial case management practices extensively, told the New York Times that she could not recall another instance in recent decades where a federal judge voluntarily recused from a case while simultaneously requesting transfer to a specific colleague known for strict case management. She explained that judges are generally reluctant to recuse because it creates additional work for their colleagues and can delay proceedings. And they are even more reluctant to request specific reassignments because it could create appearance of judges coordinating to target particular litigants. The fact that Judge Fitzgerald took both steps suggests he concluded the situation was serious enough to warrant extraordinary measures. Professor Angstrom noted that the closest historical parallel is from the Watergate era, when some judges handling Nixon-related cases recused themselves and requested reassignments to ensure proceedings would not be delayed by procedural manipulation. But even those situations typically did not involve the recusing judge explicitly identifying the litigation conduct that prompted the recusal. Don't go anywhere. The most explosive part is coming next. The reassignment to Judge Chen had immediate effects. Within 48 hours of receiving the case, Judge Chen issued a comprehensive case management order that completely reset the litigation timeline and made clear she would not tolerate the tactics that had apparently frustrated Judge Fitzgerald. The order stated that discovery would be completed within 90 days, that all pretrial motions must be filed within 120 days, and that trial would be held no later than October 2025. The order further stated that no extensions would be granted absent extraordinary circumstances beyond the control of the parties, and that any party filing motions that the court determines are frivolous or filed for purposes of delay would be subject to immediate sanctions, including monetary penalties and potential referral for disciplinary proceedings. Judge Chen also issued an order to show cause directing Trump's attorneys to appear before her and explain why they should not be sanctioned for the discovery failures that Judge Fitzgerald had identified in his orders. The show cause order required Trump's legal team to produce detailed documentation of all discovery activities they had conducted during the previous 6 months to explain why they had not completed depositions of key witnesses and to identify any legitimate reasons why discovery could not be completed within the 90-day time frame she had established. The order made clear that Judge Chen had reviewed Judge Fitzgerald's orders and shared his concerns about defense conduct and that she expected detailed and credible explanations or she would impose significant sanctions. Trump's legal team filed an emergency motion asking Judge Chen to reconsider the accelerated schedule and arguing that 90 days was insufficient time to complete discovery in a complex employment case involving multiple plaintiffs and numerous factual issues. They also argued that Judge Fitzgerald's recusal and the specific reassignment to Judge Chen created appearance of judicial bias and denied Trump fair treatment. The motion requested that Judge Chen either recuse herself or substantially modify the case management schedule to allow adequate time for defense preparation. Judge Chen denied the motion in a brief order, stating that the schedule she had established was consistent with schedules she regularly imposes in employment cases of similar or greater complexity. That Trump's team had already been given 6 months to conduct discovery and had failed to use that time effectively, and that concerns about the reassignment process should be directed to the chief judge who approved it rather than to her. She noted that she had no personal involvement in Judge Fitzgerald's decision to recuse or in his request for specific reassignment, and that she would manage the case according to her standard practices, which emphasize efficiency and adherence to deadlines. And here is what should alarm everyone following Trump's legal challenges. The events in the California case are likely to influence how judges in Trump's other pending cases view his litigation tactics and case management requests. When a federal judge concludes that a party's conduct warrants recusal and specific reassignment to a strict judge, and when that decision becomes public through court orders that are available for other judges to review, it sends a signal throughout the federal judiciary that the party in question may be engaging in dilatory tactics that require special vigilance. Judges in Trump's criminal cases and in his other civil cases are now aware that at least one federal judge found Trump's litigation conduct serious enough to warrant extraordinary measures, and that awareness is likely to make those judges more skeptical of delay requests and more willing to impose strict deadlines and sanctions. Within days of Judge Fitzgerald's recusal order becoming public, judges in 2 of Trump's other cases issued orders that legal observers immediately connected to the California developments. Judge Lewis Kaplan in the Southern District of New York, who is presiding over defamation litigation involving Trump, issued an order denying a defense request for extension of deadlines to file dispositive motions and noting that the court had already granted multiple extensions and that further delay was not warranted. The order cited principles of efficient case management and stated that all parties are entitled to timely resolution of their disputes. Judge Reggie Walton in the District of Columbia, who is handling civil litigation related to Trump's business practices, issued an order accelerating the trial schedule and stating that the case had been pending long enough and would proceed to trial by summer 2025 absent extraordinary circumstances. Both orders use language similar to Judge Chen's orders about the importance of moving cases efficiently and about the court's limited tolerance for delay tactics. Here is the tricky part. Trump's legal team now faces a situation in the California case where they must prepare for trial in October 2025 on a compressed discovery schedule before a judge who has made clear she will sanction any perceived dilatory conduct, and with the knowledge that their litigation tactics in this case have been publicly criticized by a federal judge and have resulted in extraordinary reassignment procedures. That creates enormous pressure to cooperate with discovery, to meet all deadlines without seeking extensions, and to avoid filing any motions that could be characterized as frivolous or delay-oriented. If Trump's team fails to meet Judge Chen's expectations, they face not just sanctions in this case, but also potential spillover effects in other cases where judges are now watching closely for patterns of obstructive litigation conduct. Moreover, the plaintiffs in the California case have been significantly emboldened by the judicial developments. According to their attorneys who spoke with legal publications after Judge Chen's case management order was issued, the plaintiffs view the reassignment as validation that their concerns about defense delay tactics were legitimate and that the court system is committed to ensuring their claims will be heard on the merits rather than being delayed indefinitely. The plaintiffs' legal team has indicated they intend to aggressively pursue discovery and to ask Judge Chen to impose sanctions if Trump's attorneys fail to comply fully with all discovery obligations within the 90-day deadline. They have also indicated they may seek additional sanctions related to the discovery failures that occurred under Judge Fitzgerald, arguing that Trump's team should be required to pay plaintiffs' attorneys fees and costs associated with the delays. Legal and political analysts are calling this California case development a potential watershed moment because it demonstrates that at least some judges are willing to take dramatic steps to prevent Trump from using the complexity of the legal system as a shield against accountability. University of Chicago law professor Albert Alschuler, who has studied judicial case management practices for decades and has written extensively about abuse of civil procedure, told the Washington Post that Judge Fitzgerald's recusal and reassignment represents exactly the type of judicial response that is needed when parties appear to be systematically manipulating procedures to avoid trial. He explained that the civil justice system depends on judges actively managing cases and preventing abuse, and that Judge Fitzgerald's decision to step aside and transfer the case to a judge known for strict management shows appropriate recognition that some situations require stronger judicial oversight than others. Professor Alschuler noted that while Trump and his attorneys may view this as unfair targeting, it is actually the system working as intended to ensure that all parties, regardless of wealth or status, face accountability through trials rather than being able to delay indefinitely. Do me a favor and slam that like button, because it genuinely helps this video reach more people. The rare judicial recusal and specific reassignment also raise interesting questions about judicial communication and coordination. Federal judges are generally careful to avoid appearances of coordinating with each other regarding specific cases because such coordination could create impressions of bias or predetermined outcomes. However, judges do communicate regularly about case management practices, about problem litigants or attorneys, and about effective strategies for managing difficult cases. Judge Fitzgerald's decision to request specific reassignment to Judge Chen suggests he believed the case required a judge with particular skills or approach, and his willingness to make that request explicitly in a court order indicates he concluded transparency about the reasons for reassignment was more important than avoiding any appearance of coordination. The Chief Judge's swift approval of the specific reassignment request suggests she shared Judge Fitzgerald's assessment that special case management was warranted. Legal ethics experts note that this type of judicial coordination, when done transparently through public orders that explain the reasoning, is generally viewed as appropriate exercise of case management authority rather than as improper bias. The key is that the reasons for the reassignment are stated clearly in the public record, which allows parties to understand why the reassignment occurred and to challenge it through appropriate mechanisms if they believe it was improper. Trump's attorneys did not seek to challenge the reassignment through appeal or through filing recusal motions against Judge Chen, perhaps recognizing that such challenges would likely fail given the clear documentation of delay tactics in Judge Fitzgerald's orders, and given that the reassignment followed established local rules. So, let us break down what this could mean going forward. First, the immediate impact is that Trump faces trial in the California employment case by October 2025 on a compressed schedule that leaves little room for the delay tactics that had apparently been working in that case until Judge Fitzgerald's intervention. The case involves allegations that could be politically damaging if proven at trial, including claims of wage theft and retaliation against employees who raise concerns about financial practices. A trial during the presidential campaign season could generate negative publicity regardless of the outcome. Second, the judicial actions in the California case have created precedent that other judges can cite if they conclude Trump is engaging in similar delay tactics in their cases. The documentation of delay tactics in Judge Fitzgerald's orders, combined with his extraordinary decision to recuse and request specific reassignment, provides other judges with a roadmap for how to respond if they observe similar patterns. That precedent may embolden other judges to take aggressive case management steps and to impose sanctions when they believe Trump's legal teams are abusing procedures. Third, The reassignment to Judge Chen means Trump now has a judge managing that case who has reputation for moving cases quickly to trial and for imposing meaningful sanctions on attorneys who do not comply with court orders. That creates incentive for Trump's legal team to change their approach in that case, but any change in approach may be too late given Judge Chen's initial orders and her clear statement that she will be watching for any signs of dilatory conduct. The legal team faces a difficult choice between continuing tactics that worked with Judge Fitzgerald, at least in generating delays, and adopting a more cooperative approach that might be viewed more favorably by Judge Chen, but that would result in faster movement toward trial. Fourth, the public nature of Judge Fitzgerald's recusal order and his explicit statements about defense conduct create a record that opposing parties in Trump's other cases can cite in their own filings when arguing that courts should be skeptical of delay requests or should impose stricter case management. Plaintiffs and prosecutors in other Trump cases are likely to point to the California developments as evidence of a pattern of dilatory litigation tactics that requires judicial vigilance, and judges who might have been inclined to give Trump's attorneys the benefit of the doubt on close questions may now be more skeptical. Drop a comment below with your thoughts. I am genuinely curious to see your perspective, but beyond the immediate legal and political implications, the California judicial actions raise important questions about how the legal system should handle litigants who appear to be systematically using procedural complexity to avoid accountability. The American civil justice system provides numerous procedural protections for defendants, including the right to challenge jurisdiction, to seek dismissal on legal grounds, to conduct discovery, to file dispositive motions, and to appeal adverse rulings. These protections serve important purposes in ensuring that plaintiffs must prove their cases and that defendants have meaningful opportunity to present defenses. However, when procedural protections are used not to mount legitimate defenses, but simply to delay proceedings indefinitely, they undermine the system's ability to resolve disputes and provide justice. Courts have various tools to address such abuse, including sanctions, fee shifting, and expedited procedures. But judges are often reluctant to use those tools aggressively because they worry about infringing on parties' rights or about appearing biased. Judge Fitzgerald's decision represents a more assertive judicial approach that says when delay tactics become apparent, judges should take strong action to ensure cases move forward. Former federal judge Nancy Gertner, who served on the bench in Massachusetts for 17 years before joining Harvard Law School faculty, explained in an interview that Judge Fitzgerald's approach reflects an important evolution in how judges think about case management. She noted that for many years, judges tended to be reactive rather than proactive, meaning they would respond to specific misconduct when it occurred, but would not take anticipatory steps to prevent abuse. Judge Fitzgerald's recusal and specific reassignment represents a more proactive approach where the judge identifies a pattern of concerning conduct and takes steps to ensure that pattern cannot continue. Judge Gertner suggests that this more proactive approach may become more common as courts deal with litigants who have resources to manipulate procedures and who view delay itself as a victory. This scenario is causing some concern within the legal community about whether judges are being too aggressive in managing Trump's cases and whether the extraordinary measures being taken could set precedents that affect other litigants adversely. Some legal scholars and practitioners worry that if judges can recuse themselves and request specific reassignments based on their assessment that a party is engaging in delay tactics, that power could be misused in future cases to punish parties or attorneys who are simply exercising their legitimate procedural rights. The counterargument is that judges already have significant discretion in managing cases, and that explicit transparency about the reasons for extraordinary case management decisions, as Judge Fitzgerald provided, actually protects against abuse better than informal mechanisms where judges make decisions without clearly explaining their reasoning. The debate reflects broader tensions in civil procedure about how to balance efficiency with fairness, and about how much discretion judges should have in managing cases involving parties they believe may be abusing the system. Trump himself has not yet publicly commented on the California case developments, though sources close to his legal team told reporters that Trump was frustrated by Judge Fitzgerald's actions and believes the reassignment to Judge Chen was designed to deny him fair treatment. The sources indicated Trump's team considered seeking appellate review of the reassignment, but decided against it because they concluded appellate courts would defer to Judge Fitzgerald's case management decisions and would be unlikely to reverse the reassignment absent clear evidence of impropriety. Instead, Trump's team has apparently decided to comply with Judge Chen's accelerated schedule while documenting any issues that arise, preserving the possibility of appealing those issues if Trump loses at trial and appeals the final judgment. Stay with me. What comes next will completely change how you view the situation. The show cause hearing that Judge Chen scheduled regarding potential sanctions for Trump's discovery failures took place on February 3rd. And according to reporters who attended, it was a tense proceeding where Judge Chen made clear she was not satisfied with the explanations Trump's attorneys provided for why they had not completed more discovery during the 6 months under Judge Fitzgerald. Trump's lead attorney attempted to argue that the discovery delays were due to the complexity of gathering employment records and scheduling witnesses. But Judge Chen noted that Trump's businesses maintain extensive HR records that should have been readily available, and that Trump's team had not even attempted to schedule depositions of key witnesses until after Judge Fitzgerald denied the extension request. She stated from the bench that the record suggested a deliberate strategy of minimal discovery activity designed to create justification for extension requests, and that such strategy was inconsistent with the obligations attorneys have to the court and to opposing parties. Judge Chen ultimately imposed monetary sanctions of $50,000 against Trump's legal team to be paid to the plaintiffs to compensate for fees and costs incurred due to the discovery delays. She also ordered Trump's attorneys to complete all remaining discovery within the 90-day deadline without any possibility of extension, and stated that failure to meet that deadline would result in additional sanctions, potentially including exclusion of evidence or witnesses that Trump's team failed to timely disclose. The sanctions order was significant not just for the monetary amount, but for the reasoning Judge Chen provided. She stated that the sanctions were necessary to deter future dilatory conduct and to send a message that the court would not tolerate litigation tactics designed to delay rather than to advance legitimate legal arguments. Legal experts noted that the explicit deterrence rationale in sanctions orders is relatively uncommon and suggest Judge Chen is concerned about pattern of conduct across multiple cases rather than just the specific failures in this one case. Subscribe immediately if you have not yet. This content does not exist anywhere else. What makes the California developments particularly significant is the timing. The case is a civil employment matter that would not normally receive significant attention, but it is proceeding on an accelerated timeline that will bring it to trial during the presidential campaign season at a time when Trump is facing multiple other legal challenges. The combination of Judge Fitzgerald's extraordinary recusal and reassignment, Judge Chen's strict case management approach, and the imposition of sanctions creates a situation where Trump cannot avoid trial through delay tactics and must actually defend the case on its merits. If the trial proceeds as scheduled in October 2025 and results in a verdict against Trump on wage theft and retaliation claims, that verdict would add to the negative legal narrative surrounding his campaign at a critical point in the election cycle. Oh,